Okay, I think we're going to go ahead and get started now. Good afternoon, everyone. My name is Stephanie Williams. I am the immediate past president of Women's Political Collaborative. And on behalf of the Women's Political Collaborative, our board and members, we welcome you here today for this special programming that we have put together for everyone. I would ask that before we get started, that you please make sure that your mics are muted. And preferably that your video is off, if that is okay. We may have an opportunity at some point for some questions and answers, but we will probably do that through the chat. So if you could just go ahead and do that. As you are aware today, we're here to discuss a very important case that we're very excited to have some esteemed panelists on today. We're going to be discussing the Geier versus University of Tennessee case, and the issues that prompted the litigation and the longstanding impact of this case on higher education in Tennessee. Our panelists that we are very fortunate to have today were actually personally tied to this case, starting with our first panelist, Mr. Carlos Gonzalez, who is currently the principal of the Gonzalez firm in Atlanta, Georgia. Attorney Gonzalez focuses solely on providing alternative dispute resolution services and has a long record of serving as a special master and a mediator on a variety of matters, from institutional reform litigation to complex commercial and civil rights class action cases. And in many of the cases in which he's been involved, the United States has been a party. In fact, he was the mediator in this particular case, in the Geier case in 1999, and subsequently the special master that oversaw the implementation of the consent decree that resulted from the case. Throughout his career, Attorney Gonzalez has been appointed by federal courts in several states and sought out by the Department of Justice to negotiate settlements, manage decree implementation, as he did in this case, and monitor a wide range of cases. As a special master, he had the direct responsibility for coordinating and monitoring the expenditure of over $1.5 billion, I said $1 billion, in court-ordered remedial relief. And his, interestingly enough, his first federal appointment as a special master came only 4 years after graduating law school. So he's got a hugely long career in this. And Attorney Gonzalez, we are just very honored to have you here today. We welcome you and we thank you for your presence with us here today.
Thank you very much. I'm glad to be here. I see many of my old friends are tuned in here, so that's nice to see also.
They're excited to see you. We also have with us a plaintiff, or the plaintiff from the Geier case, Miss Rita Sanders Geier herself. I will say that we are working on some technical difficulties to get her up and running on this Zoom call. But until then, let me give you all a little bit about her, with some of which you may already know, but we definitely consider her to be an American civil rights pioneer. In that when she was a professor at Tennessee State University, she was the original plaintiff in this landmark case that we are going to discuss today that led to racial integration of higher education throughout the state of Tennessee. Attorney Geier is also an attorney at law and has served as a public servant. She began her career as a history professor at Tennessee State University in the late 60s, and then subsequently transitioned into an attorney and with legal services at Seattle King County Legal Services and Legal Services Corporation, where she eventually became a regional director. She's also worked for the Department of Justice and an assistant director for commercial litigation and senior trial counsel within that office, as well as she worked in the civil division of the Department of Justice and from 1979 to 1988. She subsequently became named as general counsel for the Appalachian Regional Commission, a role that she held until 1992. But again, she was involved in the case that we're going to be talking today. So we actually get to have those players that were on the front line from this case. And we are extremely excited to have one of our very own, public servants here in Nashville to serve as the moderator today. Judge Allegra Walker. I'm sure many of you know her. Judge Walker served as an assistant public defender and an assistant district general attorney before she was elected to General Sessions Court Division 4 here in Davidson County in August of 2014. She was subsequently reelected last year for another 8-year term in 2022. And she serves as one of 3 judges that provides over the domestic violence cases in the General Sessions Courts in Davidson County. She also has a special role in serving as the presiding judge over the environmental court. She's been recognized for her prolific work in the community to raise awareness and education around issues of domestic violence, her work in supporting and mentoring women and girls, and her work is in engagement in a number of civic organizations here in Nashville. So Judge Walker, thank you for being here with us today and agreeing to moderate this panel. And at this point, I will make a plug for WPC before I turn it over to you. If you like what you hear today, if you like what you see, please consider becoming a member. We are able to provide these programs through the strength of our membership. You are able to go to the same website that you registered for this event, wpctn.org, to find out more about membership. But your membership supports us in our programming and the things that we do in the community to support our mission. So thank you for being here today, everyone, again. And Judge Walker, I'm going to turn it over to you at this point.
All right. Well, thank you, Stephanie, and thank you, Joyce, for inviting me. It's always a pleasure to serve WPC in any capacity they need me to serve in. All right. So without further ado, let's begin. Mr. Gonzalez, if you can just, I know we're waiting on Rita to chime in on the call as well, but just give the listening audience just a general overview of exactly what is Geier.
Well, good afternoon, Judge Walker, and thank you for moderating the panel today. Geier is a case that was filed in, I believe, 1968. I like to tell people I was 7 years old when the case got filed. And it involved a claim by Miss Geier and others that the state of Tennessee had operated or was operating a dual system of higher education in which the higher education opportunities for African Americans in Tennessee were negatively affected by the continuing effects of de jure segregation that had existed in the state. I think it's important. This is oftentimes called a desegregation case, but I think that nomenclature may not be exactly correct, because by the time Geier was filed, the state of Tennessee had already abandoned legalized segregation in higher education. It had ostensibly opened its institutions to all without regard to race. Now, as a practical matter, that was not at all the situation that existed in 1968. But there were 2 things that I think, and I look forward to Mrs. Geier joining us soon. There were 2 things I think that compelled Miss Geier and her dear lawyer, now deceased, and my dear friend George Barrett to bring the lawsuit. And the first one was the fact that UT Nashville had come into the downtown area of Nashville and was beginning to grow its academic programs to the detriment of Tennessee State University, the state's only publicly supported HBCU. And as UT Nashville, sometimes referred to as UTN, began to expand, Mrs. Geier saw that it was having a negative impact on the ability of TSU not only to grow its enrollment and its academic programs, but to serve its students in an important and educationally sound way. So that was one aspect of the lawsuit. The other aspect of the lawsuit was to remove the vestiges of segregation that still clinged to the system of higher education in Tennessee. So the primary impetus at the time that the lawsuit was filed was to, on the part of the plaintiff or plaintiffs, it was a class, was to get UTN closed down. That was the primary legal objective, initial legal objective. And then secondary to that, again, was to challenge generally these vestiges of segregation that Mrs. Geier and George Barrett and others felt continued to cling to the system.
All right. So when we talk about vestiges of segregation, I've read a couple of articles written by several different sources that kind of described some of these vestiges of segregation. Can you go in and talk about like what were some of her what were some of the issues and what were some of her concerns, because she was a faculty member at TSU during the 60s, is that correct?
That is correct. She was an adjunct. I believe Mrs. Geier was an adjunct faculty member while she attended Vanderbilt Law School. Mrs. Geier had graduated from the University of Chicago, I believe, at least with a graduate degree, and then came to Nashville and enrolled at Vanderbilt Law School.
And Geier also is a graduate of Fisk University.
Oh, correct.
That plug in there.
And Fisk as well, yes. Mrs. Geier comes from a very prominent and well-established family in Nashville, very important family. But the vestiges of segregation generally fall along a continuum, but they generally impact the ability, the programmatic offerings at institutions. You have to remember that all of these vestiges of segregation are cited in the history of these institutions, in the history of African-American collegiate education, not only in Tennessee, but there's a similar story across the, for want of a better word, the old Confederacy, where African-American institutions grew up following the Civil War, and then many of the institutions became colleges, universities, and this sort of thing. Public, I'm talking about the public HBCUs. And unsurprisingly, those institutions were created by the state, but not necessarily, or not at all, really supported by the state. And so it's the effect of that lack of support, both financially, programmatically, in terms of the physical plant, just all of the indicia of a well-established institution of higher education, state-supported higher education, were largely missing from these HBCUs. And TSU, did valiant work, but they were very much constrained in their ability to grow the institution and to serve the citizens of Middle Tennessee. So that was, again, vestiges run the gamut of the academic endeavor, from administration down to athletics to fundraising, endowments, the whole package. So in these cases, all of those issues are essentially on the table. And plaintiffs that can draw a direct line back to the de jure period of segregation, that is the legalized period of segregation, and show how those currently had current impacts in the academic institution, those claims under the Fordyce standard that the Supreme Court announced, those claims those issues have to be remediated. And that's what Geier was essentially about.
Okay. Now, if I could just add on, when we talk about some of those vestiges of the desegregation, I think it's also important to know that the faculty salaries at Tennessee State and some of these other state institutions were significantly less than salaries at these other institutions that we saw flourish as well during this time.
That's absolutely right. And you make a good point, Judge, because it's also important to remember that the traditionally white schools, the UTs, the MTSUs, the other part of the educational system, they also suffered from these vestiges of segregation, right? They had, in some cases, a very low enrollments of other race students, primarily African Americans. In many regards, almost no faculty of color on their faculties. Certainly no full professors and that sort of thing. High-ranking faculty were non-existent. And so those two are vestiges of segregation that have to be remedied according to the standards announced by the Supreme Court in 1992 in this Fordyce decision I referenced.
And just out of curiosity, and you mentioned other institutions, HBCU institutions particularly throughout the South, also had issues like TSU. So the question is, were there other, after the Geier decision or during that litigation, were there other institutions that also saw litigation that kind of stemmed out of the same issues that arose from the TSU litigation?
Absolutely, Your Honor. There were a number of those cases. There were three very active cases. The whole history of how these cases started is a day for a discussion for another day. But I was also the special master in a similar case to Geier in the state of Alabama called Knight v. Alabama, which is a very similar case. There's and then there's the Fordyce case that I've referenced. That was in Mississippi. So Alabama, Tennessee, and Mississippi were very actively litigated during the same time frame. And this would have been in the, as I said, Geier got filed in 68, I believe, 1968. But the real, it was very active, and then it had a period of dormancy, and then it picked up again. But generally, these three cases were very active in the 80s and 90s, and then into the early 2000s. There's a lot of commonality between at least I'm very familiar with what went on in Alabama and what went on in Tennessee, and there's a lot of commonality between the cases because the history of segregation and racism and Jim Crow is very similar throughout the states in the South. Now, Tennessee, may not believe me, but Tennessee had a less torturous history on race issues than some of its sister states. That's particularly true in higher education. I think to some degree in K-12 as well. Certainly there was no governor that stood in the schoolhouse door the way Wallace did in Tuscaloosa. So, and Tennessee was one of the first states, it's worth noting, was one of the first states to do away with its prohibition on African Americans attending white collegiate white colleges in the state. In fact, I think it was 1962, maybe as early as 62, 63, when Tennessee did away with legalized segregation in higher education. Again, I don't want to be naive. Just because the law changed didn't mean that the circumstances changed. But it's, I think, important to recognize that.
How long was this case in litigation?
Well, it got filed in 1968, and as I said, was very active. At the time it was filed, Judge Gray had it. This is in district court, federal district court in the Middle District. It got filed in 68, and we closed it out in 2006, I believe. So there were a lot of kids sent to college on this case, I guess. And again, it was very active when Judge Gray had it. And ultimately, and many of you know this history, ultimately, Judge Gray ordered the merger of UTN, University of Tennessee at Nashville, into TSU, which was the first time anything of that kind had ever occurred in the country, in which a historically white educational institution was taken over by a historically Black institution. So that was very significant. That was an order of Judge Gray, who imposed the order, and then died a few years later, and Judge Thomas Wiseman took over the case when he went on the bench in, I think, 1977, something along those lines. Judge Gray oversaw the initial effort to integrate UTN into TSU. It was a very difficult, tortured effort that Judge Wiseman inherited, and dealt with that and the other issues, many issues in Geier, until the case was dismissed. So the case had two judges on it, Judge Gray and Judge Wiseman.
So, I mean, we're talking about litigation that spanned, almost 40 years.
Yes.
I mean, why did it take so long? And then I'm just really kind of interested, what were the legal, the political, and the educational challenges surrounding that case? Drawn out so long.
Right. It took so long, I think, in part because there was not a clear standard as to how to judge the state's conduct, as to what it meant to remove vestiges of segregation. That was not announced by the Supreme Court until 1992. That's one thing. The other thing that took so long is that you can imagine the challenges in trying to merge UT Nashville into TSU and what that meant in terms of the ongoing program at UTN and the ongoing program at TSU. There were a case of this nature, and I see my good friend Bob Cooper and I think Justin Wilson are on listening now, and they could attest to this better than I can. But the political issues in the case, when I got involved in them in the case, and certainly well before that, were monumental, very, very challenging. The educational issues were very challenging. How you can just sort of guess why it was so difficult, what Judge Gray ordered done. You had faculty that had been UT faculty and now were TSU faculty. That created a series of challenges and frankly some resentment on the part of of a number of folks on both sides. There was a concern at one point in this lawsuit that in order to meet the standards that the state thought had to be met, and that frankly Judge Wiseman thought had to be met, there was some grave concern that TSU would lose its character as an HBCU all in adherence to the obligation to desegregate. So that was a very, very tense issue in the case, and caused tremendous discord and difficulty for the court and the parties, the litigants, the state, the whole thing. So it became very political at that point and at that level. And there's one thing I learned a long time ago in dealing with academics is that, the capacity of faculty and administrations to resist is essentially unlimited. And that's true at UT, as much so as it is at TSU. So, there was a lot of those kind of issues. Educationally, there were obviously concerns about losing programs and this sort of thing, and the effect that elevating TSU academically would have on proximate institutions, geographically close institutions like Austin P and MTSU. So there was a lot of concern about those issues as well, because one of the claims was, and it's one of the easiest vestiges of segregation to spot, is that the academic programs at TSU were artificially retarded in their growth. And so there was a concern that if TSU got PhD programs or first professional programs and this sort of thing, that it's a zero-sum game, and that means that MTSU loses out or Austin P loses out or what have you. So there was the constant pull and tension between institutions. And Judge Wiseman was trying to deal with all of these issues and trying to compel the parties to find a resolution.
Got it. So when we talk about a settlement that came out of Geier, is there a monetary amount to that? And if so, how much?
I'm sorry, Your Honor, could you repeat that?
Was there a monetary amount that was awarded out of the Geier settlement?
There was a lot of relief that was very expensive. I wouldn't say there was a dollar amount awarded. It's important to recognize that the state, largely under Governor, I can't remember anyhow. I'm sorry if I forget his name. The state invested almost $200 million in TSU's physical plant. And McWhorter, under Governor McWhorter, the state invested roughly $200 million, I believe, in TSU. Now that was after Mrs. Geier and George Barrett pressed the matter in court, but eventually, as part of an initial settlement, there were very significant expenditures on facilities at TSU to upgrade those facilities, because the state had essentially abandoned TSU to its own devices with regard to facilities. So that was sort of the first big tranche of expenditure. And then in the settlement that we negotiated in 1999, the last settlement, there was not specific dollar amounts, but again, there were specific obligations on the part of the state to pay for certain programming and some enhancements to the old TSU, UTN building, and what have you. At any rate, I think when it was all said and done over the life of Geier, I'm sure the state spent in excess of $700 million, maybe something a little less than that. It was very substantial. But I will say, Judge Wiseman, through his force of character and just his insistence, secured a settlement agreement back in the mid 90s that proved very unworkable in part, and continued to drive the political and educational problems that came to a head around the time that I was brought in to try to mediate a second settlement of the case. That the initial settlement that the parties reached in the mid 90s just proved utterly incapable of addressing many of the issues that were confronting the state. And it was in fact tearing the system, both systems, the UT system and the TBR system, it was just tearing them apart and causing all sorts of political problems for everyone. And that's when I was brought in to see if we couldn't bring some order out of chaos.
So the mediated agreement that you helped orchestrate came about in what year?
That would have been, I think the court approved it toward the end of 1999, maybe 2000. I should know the exact date. I'm sorry about that.
A long time ago, so it's okay.
It was the court approved it on December 19th, 2000. And that was after a year of mediation. It took a year of mediation. And again, I see Justin Wilson is on the program or here, and he played a very instrumental role in helping get us through that first, getting this year-long mediation process, bringing it to conclusion, as did a whole number of people. And just a tremendous number of people were involved in that from both systems, and the faculties. There were some interveners from TSU that Judge Wiseman allowed in the case. Dr. Coley McGinnis and Dr. Ray Richardson, who were very instrumental also in helping bring cohesion and agreement to these disparate parties as we work through these issues.
All right, so we go from the mediated agreement from 1999 and that to 2000. What happened in 2006? Because the parties agreed to dismiss this case. So I just want you to give us more details on what happened from 2000 to 2006 of that dismissal.
Well, there was a lot of work that went on. The remedial decree, it's the consent decree, excuse me, that the parties entered into in December of '99 was very reticulated, very detailed in some aspects, and in other aspects was intentionally vague. One of the principles that I brought to the table that I think helped cut the thing loose was that we agreed that we would try to do as much of the relief work, the remedy work that needed to be done within the structures that the state has in place for managing higher education. You have the Tennessee Higher Education Commission, for example, PHEC, that deals with programming and making sure there's not any unnecessary duplication among programs, for example. So that was one thing that we needed to be very aware of. There were already in place a number of, in those days, affirmative action type programs that the state had agreed to, or the institutions had agreed to follow, that needed to be beefed up a little bit and what have you. So there were just a lot of moving pieces that had to be managed. And we managed those pieces. I managed those pieces by calling on the resources that the state already had in place, personnel resources, that sort of thing, personnel, in order to facilitate implementation of this decree, which again covered things from faculty hiring, student scholarships and retention, fundraising for endowments, all sorts of new programs, some PhD programs, renovation of the Avon Williams campus, that is the old UTN building, downtown Nashville. There was just a host of stuff that was going on, and everybody was engaged in it. The critical junctures in this lawsuit occurred when there was a change in administration in Tennessee, but from the Sundquist administration to Governor Bredesen's administration. And that transition period was very delicate, but beautifully managed by Justin Wilson and Bob Cooper, who at the time I think was Governor Bredesen's legal advisor. He went on to become Attorney General, but at any rate, that transition period was very dicey, and it took a lot of management to get through that sort of thing, to make sure the funding that we had secured under Governor Sundquist continued, and that the programs, because these things take a while to get done, that the program process would continue and that sort of thing.
Got it. So, in your opinion, what do you think the impact of Geier has been on the Nashville community per se, and I guess statewide community as well, because it really impacts systems across the state. But I really want to kind of hone into the effect it had here in Nashville.
Well, I think it's had multiple impacts, some of which have diminished over time, some of which continue. I think that importantly, it required the state to recognize that in Middle Tennessee, I'm talking about Davidson County in Nashville area, that the state had already established TSU, and that TSU was entitled to be in Nashville and was entitled to grow its institution just as any other institution would have been allowed to grow. And that has had continuing impacts. I mean, there is no doubt that TSU is a much better institution for what Mrs. Geier and George Barrett and others did than perhaps would have been the case if UTN had been allowed to stay in Nashville, and undoubtedly would have grown, because it was on a very fast trajectory. UTN was at the time that Miss Geier brought her claims. So I think just as a practical matter, Geier had the effect of establishing TSU as the institution in Middle Tennessee. Now, you certainly have MTSU, which is just down the highway, and Alston P as well, but they too were established around the same time that TSU was established. But I think that is sort of in the Nashville area, that is a critical piece of it. And that TSU is an institution where academic programs can be established that meet the needs of the business community and the other interested parties in Middle Tennessee. It's not to the detriment of schools like MTSU or the two-year colleges or things of that nature, but it did sort of force that recognition on the state, and I think that is its ongoing long-term impact. None of this is perfect. The number of faculty of color at UT and in Memphis and at other institutions is still not where I think anyone, including UT, would want them. But they are, those are all ongoing struggles and obligations that people of goodwill have to continue to work on. I just as a legal matter, I think it's important to recognize one critical piece. When the Supreme Court decided the Fordyce case, and again, the Fordyce case is the case that set the standard that the state has to meet to remedy these vestiges of segregation cases in higher education. Justice Thomas, I don't normally agree with Justice Thomas on much, but on this issue, it may come as a surprise to some that he, in a concurrence, he was with the majority and he concurred. And in his concurrence, he said very directly that the historical fact that TSU, at that time it was the colleges in Mississippi, but the historical fact that TSU is predominantly African-American is not itself a redressable vestige. In other words, he was saying that simply because an institution is a majority one race or another does not itself mean that the state is not in compliance. And that was very critical, particularly coming from Justice Thomas, because there was a lot of concern, as I mentioned a few moments ago, that the end result of these cases that were pending in Mississippi, Alabama, Tennessee, and were agitating in other states would be the demise of the HBCU, that would be the end of them. Because if we got to desegregate, that means you can't have a single predominantly one race school, particularly composed of the minority race within a geographical area. And the Supreme Court put that issue to rest. That was one of the issues that caused Judge Wiseman a lot of consternation in his administration of the case. And so once that decision got made, everyone was then able to focus on the changes to the academic structure that needed to be in place, the academic system, collegiate system, in order to meet this new standard that the court had set out with regard to these vestiges. And in the end, the plaintiffs in the case, and the plaintiffs included not just Ms. Geier, but the United States. The United States was also a party plaintiff in this case. And in 2006, they agreed that the state had fully implemented the consent decree that we had all negotiated, and that the state, they were entitled to a dismissal of the case. And Ms. Geier agreed with that, and the United States agreed to that. And one of the keys to getting that done, frankly, was that when we negotiated the agreement, we all agreed, that is, the council for all the parties agreed, that if the state did what was in these papers, in this consent decree, that we would all agree that that would constitute compliance and warrant the dismissal of the state from the lawsuit, dismissal with prejudice of the claims. And to everyone's lasting glory in that case, the state did what the state said they would do. The institutions largely did what they said they were going to do. And the plaintiffs agreed that was sufficient, at least with regard to the case. Now, it doesn't mean that the challenges are over. It just means that with respect to the Geier lawsuit, it was at long last concluded.
So
And I think that was Judge Wiseman's happiest day.
here's my question, because here recently we saw, I guess in the last session, where Representative Harold Love kind of led a charge with the state in some remaining monies that was owed to TSU. And I forgot how many millions of dollars was owed. Was that part of that monies kind of set aside from the Geier settlement, or is it something different?
I don't know the answer to that. I know that as we negotiated the exit for Geier, we there were some leftover monies that were dispersed to TSU, I believe, and to the other institutions for a variety of the programs that they had instituted. I believe all of the Geier money that was anticipated to be spent was in fact spent. I'm not sure what might be left over, what you're referring to, Your Honor.
Another question that I have within the litigation, and I know it's a fine line that you have to walk with this kind of conversation, but were there just blatant kind of intentional discussions on the treatment of TSU was just flat out institutionalized, systematic racism? Did anybody ever really kind of get into that, or?
Oh, you can be sure of it. I don't know if you know Dr. Raymond Richardson, who was a math professor at TSU, but he never walked away from a discussion. He was a very strong driving force in this matter, as was Coley McGinnis. Coley was a white professor. He was a former UTN professor, and Ray was a senior professor at TSU. Mrs. Geier at this time was in Washington working for the Social Security Administration. She was still active in the case, but there was a lot of discussion, constant discussion about the impact that these vestiges, that these activities, that these policies that the state had in place were having on TSU, and still having. And I think if you talk to Dr. Richardson, he would tell you that there's still some impacts from those policies. This lawsuit is not about removing all of those vestiges once and for all. It's a constant struggle, as you well know. Defending and preserving your institution. Some of it's got nothing to do with race. Some of it has everything to do with race. But with regard to hard discussions, you bet there were. You bet there were. And it was difficult. It's a whole host of issues that come up because people come to problems like this with different perspectives. Mm-hmm. And in order to get it settled, you can imagine, I mean, I can't remember the exact number. You have 7 or 8 senior institutions in Tennessee. Then you had all of these boards of, you had the TBR board at the time. They managed all of the institutions that weren't under the University of Tennessee. And so you had all of these conflicting challenges. And you had a lot of tension between TSU and its board of trustees that had to be dealt with. So yes, certainly there were these issues that continued to be discussed throughout the entire case.
And I'm gonna do one last question before we wrap up and take some Q&A from the audience. Where do you see there's room for improvement post-Geier?
Where's there room, Your Honor, for improvement?
Mm-hmm.
Well, I think there's a number of areas for improvement. Certainly ensuring that other race faculty, and by that I mean largely white faculty at TSU and African-American faculty at UT and similar historically white schools, that the endeavor to secure appointments of other race faculty should be a focus. You know, I don't know what the program inventory looks like now. One of the things we tried to do in Geier, one of the things that Mr. Barrett and Miss Geier were insistent on that we try, was to get a law school at TSU at one time. Those discussions ultimately did not produce anything except a lot of heartache. So there's still some programmatic objectives, I'm sure, that TSU has and that Alston P and that MTSU have, but they've all got to work together because, now being 30, 40 miles down the road is not an impediment to somebody in Middle Tennessee. In other words, you jump on the highway, you're at MTSU or you're at TSU. And so there are those challenges. Again, Geier didn't answer all the questions. It tried to deal with the immediate remnants, vestiges of these terrible policies that the Southern states imposed on African Americans and African American institutions during the period of Jim Crow.
Got it. All right, well, at this time, and thank you, Mr. Gonzalez. I think I've been in my office for too long with no movement, and I think my light went out. At this time, we're going to take some question and answers, Q&A from the audience. You can type your question into the chat, and we'll talk about it. I'm going to get my light turned back on. And if anybody has any questions, feel free to type that into the chat and we'll discuss it.
I see that Mary Barrett is online. She is George Barrett's daughter. So I'm glad to see her here.
I also wanted to acknowledge Ms. Geier is on the Zoom with us, but she is unable to get her microphone, but she is here.
Good.
All right, so we got a question from Ms. Danielle, who is in higher education herself. Do you think that the impact of the Focus Act in 2017, what do you think the impact of the Focus Act is on 2017? In other words, where institutions got their own boards will have on the progress previously made under Geier. So we're asking about the impact of the Focus Act.
The focus is that the act that gave all of the institutions that were under the TBR a separate board of trustees? Is that?
Yes.
Yeah.
Yeah. What impact will that have on the progress previously made under the Geier decision?
Well, I'm not sure what impact it will have under the progress that we made at TSU. I remember when that act was passed, thinking that seemed troubling to me. I understand why an institution would want its own board of trustees, but having a lot of experience in Alabama, where every institution in Alabama had their own board of trustees, I knew that creates a lot of challenges for administering higher education. But that's neither here nor there, I suppose. I don't know what impact it would have on TSU. I suspect, I don't know this, but I suspect TSU is certainly glad to have its own board. And it may make policy one of the challenges in Geier was how to set the various policies and to do so within the structure that the state had in place at the time. That structure is vastly different now. A separate board of trustees for an institution is certainly a reasonable way to secure your policy objectives, perhaps, but it also creates some real political challenges, especially when it comes to getting down in the legislature and getting money and all that sort of stuff.
And I guess we saw some of that kind of play out in front of us this year with Tennessee State and the legislature as they discussed monies and opportunities to do different things. That segues us into a question from Judge Rachel. How long do you think it'll take for TSU to be fully restored with their funding that's been withheld from the state? I think somebody may have mentioned that dollar amount that Representative Love had discussed and advocated for was about almost 500 million. It seems like that's a lot of money too. Hundreds, I know it was hundreds of millions of dollars. I don't remember what the exact dollar amount is that's been withheld still to this day from TSU, but how long do you think that might take?
I really have no idea. I'm not involved in the politics of higher education anymore. I think that's a purely sort of a political question. I think you better marshal your resources and show up at the Capitol and advocate. Same way UT does it, and the same way MTSU does it.
Mhm.
Politics is on its own timetable.
Got it. So, and someone chimed in to say it's about $500 million. So I was reading the right thing. It seemed like a lot, but about $500 million is what Representative Love suggested the state still owes Tennessee State. So our questions from Ms. Brianna says, you spoke about the resistance of faculty members throughout the state. So that's TSU as well as other members the UT system. To what extent that you're able to, can you provide some examples with respect to what the resistance would look like?
Well, I can talk about what we did in Geier. And when I talk about resistance, I mean resistance to the expansion of high demand programs, the competition for high demand programs, the ability to question the academic program at an institution. That's what I mean by resistance. It wasn't that there was massive resistance in the sense that you think of when you think about K-12 integration and all of that. It's more that academic resistance where faculty dispute and engage in almost endless discussions. Becomes a disquisition on this, that, or the other, and it's those kind of challenges where resistance can pick up. Faculty hiring. Faculty hiring is usually done at the departmental level. So you can imagine that within a department, you don't have consensus over a client. I mean, over a candidate or something like that. So it gets very contentious, and there's just a lot of resistance. And you see that a lot in the hiring of minority faculty, unfortunately. I'm not saying it's how widespread it is. Again, I've been out of the higher ed business for a while, but I suspect it's still an issue.
Okay. All right, well, it is now 1:01, and we're going to have to leave this very fruitful discussion. That was very fascinating, actually. I remember years ago, and probably like 2-3 lives ago, I was an intern at the Board of Regents back in, I think 1996. So it was pretty much still a hot topic back in 1996, along with building the stadium as well. So TSU has been involved with the state with lots of attempts to have some equity. But we'll have to end. I do appreciate Ms. Geier coming in, as well as you, Mr. Gonzalez. I also want to remind everybody that your CLE forms will be turned in and you will definitely receive credit. Thank everybody out there in Zoom land who have come on to hear this discussion. I think we had about 62 that chimed in within this hour. So with that and no further ado, I will sign off and allow you all to get back to
Judge.
your Friday afternoon. So
Thank you all. I
right,
appreciate
thank
you
you.
listening.